Okay, we can go ahead and get started then. I have the pretrial order in front of me for reference. Can I get appearances from the parties?
Yes, Your Honor. First, would you like appearances from the government?
Sure.
My name is Riya, Lakkaraju, and today I'm joined by my colleague, Ms. Sara DeLacy.
Good afternoon, Your Honor.
Good afternoon.
And we'll be representing the United States.
Good afternoon, Your Honor. My name is Travis Harper, joined here today by my colleague, Ms. Stella Asmara.
Good afternoon, Your Honor.
Good afternoon.
Together, we represent the defendant in today's case, Mr. Augie Shepard.
Perfect. And then do we have any housekeeping matters to attend to? And I will ask the audience to silence their cell phones, please. Thank you.
Yes, Your Honor. Excuse me, Ms. Lakkaraju.
We have a couple housekeeping matters, Your Honor, if we could attend to those.
Absolutely.
First, we'd like to invoke Rule 603 and 615 for the constructive pre-swearing and sequestration of all witnesses.
Yeah, that's granted.
Yes, Your Honor. And next, we'd like the court to take note that there are a number of witness statements and expert reports that are prepared by unavailable witnesses in this case. That's Exhibits 3, 4, 5, and 6. And we'd like to move those into evidence and also tender them to the jury at this time.
Any objection?
Yes, Your Honor. We actually were going to have a substantive motion moving to exclude one of those exhibits, specifically Exhibit 5. Would you like to deal with that motion now, or would you like to wait to hear the rest of the housekeeping matters first?
Does this jurisdiction allow substantive motions?
Yes, Your Honor. In this particular phase of the competition, there are substantive motions.
Sure, like I said, we just received the updated information now. Let me go ahead and let's handle that now. You said Exhibit 5?
Exhibit 5, Your Honor. Yes, it's an expert report by an agent named Jess Falkenstein.
Give me 1 second to find it. Does anybody happen to have a page number?
30, Your Honor.
Thank you. Okay, so we have an expert report from Ms. Falkenstein, and she is unavailable. Okay, and you wanted to move this into evidence?
Yes, Your Honor.
Okay, I'll hear your motion.
Yes, Your Honor. Would you like a factual background of the case before we go into the substantive motion?
No, I'm okay, thank you though.
Yes, Your Honor. The state actually retained an expert, or an alleged expert in organized crime, to opine as to the nature of this crime and whether or not it matches organized mob killings. But, Your Honor, they're not intending on calling this witness to the stand, and they won't be subject to cross-examination. For those reasons, we actually have an objection to the admittance to the middle of this expert report on grounds of Rule 702B and Rule 702C. Your Honor, pursuant to Rule 702B, we need to have sufficient facts and data. Your Honor, this witness was not involved in this investigation whatsoever. She didn't go to the crime scene, didn't investigate any witnesses, didn't talk to any witnesses, didn't look at any physical evidence, but she only reviewed the exhibits in the case. Not just that, Your Honor, if you look at that expert report, by this witness's own admission, she's unfamiliar with organized crime in the West Coast. Your Honor, this crime, it was committed here in Los Angeles. This expert doesn't have sufficient facts and data to opine as to a mob killing in Los Angeles if she's not even familiar with how the mob operates in Los Angeles. Moving on to Rule 702C, this expert also doesn't have a clear method in their report. She states that she used what she knows about organized crime and compared it to what the facts of this case. But frankly, Your Honor, she doesn't include any methods of analysis and none of the standards that we would expect to see in a daughter hearing like this, whether that's whether that method's a gold standard in the field, if it has an error rate. What types of analysis does she use? Does she use a regression? What does she even look at in the first place? We have none of that information, Your Honor. Frankly, I could look up a book of the De Bruno crime family and their history, look at the facts of this case, and say I could come to the same conclusions. And that's not sufficient to reach an expert method under Rule 702C, and certainly not a reliable method at that.
Response, counsel?
Yes, Your Honor. We'll take each of those arguments one by one. First, we believe that he's objecting specifically to 702B and 702C, so we'll start with our response to 702B. Your Honor, the question there is really just whether or not this expert, Ms. Falkenstein, had sufficient facts and data when she was forming her opinions. Your Honor, she certainly did. You'll see in this expert report that she analyzed extensive evidence, but Your Honor, even more than that, she's been investigating the crime syndicate, the De Bruno crime family, for many years. And first, I'd just like to clarify, it's not just an investigation of the crime family, Your Honor. One of the conclusions that this expert witness comes to in her report is that the defendant, in this case, was the leader of that crime family, the same person on trial. Your Honor, that's exactly why this report is very important for the jury to hear. Second, to Mr. Harper's point that she did not have reliable methods, Your Honor, we believe she did. In this report, she says that she used a comparative analysis. But even more than that, Your Honor, you'll see in this report that this witness has been accepted by the court as an expert in organized crime, the same exact field she'll be forming opinions on, in this case, 11 times before this trial, with the same methods after reviewing the same evidence.
Response, Your Honor?
I have a quick question for the government. So you're not planning on calling this witness to the stand, correct?
We will not be calling this witness, Your Honor. This witness is unavailable.
So through what method are you planning on just admitting this and providing it to the jury to read, or will?
That's correct, Your Honor.
witnesses-
We plan on admitting this document and then tendering it to the jury prior to opening statements.
Okay, response.
Your Honor, the fact that this witness testified in a trial is actually pretty important, because in a trial she's subject to cross-examination, has to lay foundation. We will be able to ask her questions about her method and then re-raise any objections that we have to this testimony. Because the government is choosing not to call this witness, we're not entitled to that cross-examination, and we don't have enough foundation on the record for this to be a reliable method. Just because she's testified in other cases before doesn't mean that this report, in which that was not subject to cross-examination, has a reliable method, Your Honor. And I'd just like to reiterate on the 702B grounds, this witness says she is not familiar with organized crime in Los Angeles. And frankly, Your Honor, it's inconceivable that an expert opining as to an alleged mob hit in Los Angeles doesn't even know how mob hits in Los Angeles actually work. That's insufficient facts and data under Rule 702B.
Response, Your Honor?
Sure, since you are moving this in, I will let you have the last word.
Yes, Your Honor. First, I'd like to address Mr. Harper's point on the geography. We don't care whether or not the defendant in this case was actually from Los Angeles. In fact, Your Honor, we're going to argue today he was not from Los Angeles. He was here on a trip. He's a member of a crime family that's located in Philadelphia. And as a member of that crime family, after a witness in this case testified against him, that's when he traveled to Los Angeles. Your Honor, it's not necessary for this witness to opine on how mob hits in Los Angeles work. We're not saying the defendant actually operated any crime syndicate from Los Angeles. In fact, we don't think he did. And Your Honor, as to the second point, the witness, the fact that she's been accepted as a court, as an expert in this exact field, and forming the opinion specific to the defendant in this case is extremely important. She used the same methods. She relied on the same information. But Your Honor, this time she's opining on someone that is being tried in this case, and that's important for the jury to hear.
Okay, if you give me 1 minute, I just want to make sure that Okay, I take the defense's argument. I understand that there are confrontation clause issues with this, but that we've waived constitutional objections. So I do take your point about the issue with cross-examination, but because we're only handling this as a 702 issue, I'm going to overrule the objection. I'll admit the report on those grounds while acknowledging that if we hadn't waived constitutional issues, we would be having a different conversation.
Yes, Your Honor. And Your Honor, we'd just like to clarify, now that we've dealt with the Exhibit 5 issue, would it be all right if we tendered Exhibits 3, 4, 5, and 6 to the jury at this time and admit them?
Pardon, is that all right?
No objection. We stipulated they were admissible.
Sure, we can go ahead and move those in at this time. Let's actually hold off on providing them to the jury until the record is open after opening statements, when we can provide evidence to them.
Yes, Your Honor. Next, Your Honor, we just have one more housekeeping matter. Since we've never had the pleasure of appearing in your courtroom, we'd just like to ask about your preferences. Would you like us to ask permission before approaching opposing counsel, Your Honor, the members of the jury and the witness?
Please ask before approaching adverse witnesses, the bench, and the jury.
Yes, Your Honor, and with that, we're ready to go.
All right. Anything from the defense?
Yes, Your Honor, just one housekeeping matter. And maybe assume that Mr. Shepard is constructively sitting at counsel table for his trial.
Of course.
And with that, we're ready to go to opening statements.
All right. The government, whenever you're ready.
Yes, Your Honor. May I proceed?
You may.
Your Honor, Mr. Harper, members of the jury. He took a deal. So the defendant took his life. It's October of 2018. And a man named Barry Capello is testifying in a courtroom. Members of the jury, you're going to learn today that Mr. Capello, he's facing years in prison, but he has a way out. You'll hear that he has a deal with the government. A deal to testify against the mafia in exchange for spending the rest of his life in witness protection. Members of the jury, you're going to learn today that Mr. Capello took that deal. Stood up in court, told the truth. But you'll learn that our story doesn't end there. Because members of the jury are going to hear that 3 years later, in June of 2021, Mr. Capello was found murdered, strangled in cold blood, right outside his own home. And why? Members of the jury are going to learn that it's because Mr. Capello took that deal. So this defendant took his life. That's why we charge the defendant with 2 things: murder and witness retaliation. That means that we have to prove to you today that the defendant killed Mr. Capello, and that the reason he did that was because Mr. Capello testified all the way back in 2018. And we have to prove that to you today beyond a reasonable doubt. We know that's a high burden, but it's one we're going to meet. And we're going to meet it by talking to you about the deal that Mr. Capello took and how the defendant took his life. So first, that deal. Because members of the jury today, you're going to hear that after Mr. Capello testified in 2018, he was placed in witness protection. A U.S. Marshal is going to take the stand today and tell you that Mr. Capello was moved all the way across the country to Los Angeles. He'll tell you how Mr. Capello was given a new name, a new identity, a new life. Members of the jury are going to hear that in June of 2021, this defendant found him. And that just hours later, Mr. Capello was murdered. And that brings us to our second point: how this defendant took Mr. Capello's life. Because members of the jury today, you're going to hear a lot about what the defendant looks like and what kind of car the defendant drives. You're going to hear that the defendant is a white man, 5'10", 180 pounds, drives a green Ferrari, and has size 11 shoes. And members of the jury are also going to hear that the night Mr. Capello was murdered, a white man, 5'10", 180 pounds, driving a sports car, pulled up to Mr. Capello's house in the middle of the night. We're going to hear how he waited for Mr. Capello to leave his home. And then you'll hear how, filled with rage, that man took a set of jumper cables, wrapped it around Mr. Capello's neck, and pulled and pulled and pulled until Mr. Capello couldn't breathe. Members of the jury, for the rest of this trial, I want you to pay attention to the deal that Mr. Capello made. But also pay attention to the descriptions of the man who killed him 3 years later. Because we're confident that if you do, you'll see that after Mr. Capello took that deal, this defendant was the man who took his life. That's why at the end of this trial, I'm going to come up here again and ask you to find this defendant guilty. Thank you.
Thank you. Opening from the defense.
Yes, Your Honor.
And before you begin, sir, I'm once again going to ask the members of the jury and all the spectators to please make sure your phones and computers are silenced. Thank
Your
you.
Honor, very briefly, just before Mr. Harper begins his opening statement, permission to tender those exhibits we talked about earlier to the members of the jury.
We will tender after the record opens, which will be after both openings.
Apologies, Your Honor.
Not a problem.
May I proceed?
You may.
May it please the court. Ms. Lakkaraju. Members of the jury. People see what they expect to see. It's June 2021, 1 a.m. And a quiet suburban neighborhood in Los Angeles is swarmed with police cars. A U.S. Marshal walks up to the crime scene, tightens his jacket in the morning chill, and looks down at the one thing he had never hoped to see. a witness that he had relocated, was dead on the ground. He thinks, how could this have happened? I put this man in witness protection. I relocated him. I was responsible for him. This must have been the mob. The night that that marshal walked to that crime scene, he was expecting to see a mob here. And so he did. And the government, they ran with it. Even if the evidence didn't match up. But that's not okay in a criminal trial like this. Because when Ms. Lakkaraju filed criminal charges against Mr. Shepard, she took on a burden of proof, to prove their case beyond all reasonable doubt. That means it's her job, and her job alone, to prove to you every single element of those two charges. Not until it's possible, or probable, or likely, or more than likely. They have to convince you that Mr. Shepard is guilty beyond all reasonable doubt. Heaviest burden in our legal system, members of the jury, and as you hear the evidence today, you'll learn it's not a burden these prosecutors will be able to meet today. Why? Because people see what they expect to see. And these prosecutors, they saw exactly what they wanted to see. But how do we know that? Well, over the course of today's trial, I want you to pay attention to 3 simple facts. And I want to walk through those one by one. First, the state, they don't have any forensic evidence tying Mr. Shepard back to this crime. You know, in a criminal case like these, what do you expect to see? Maybe DNA, fingerprints, security cam footage. The lead investigator on this case is going to take that stand, and we expect he's going to tell you he didn't find a single one of those things tying Mr. Shepard back to that crime. So you may be thinking, what about the witnesses? Did someone see this? That brings me to fact number 2. The state doesn't have a single reliable eyewitness. You see, Ms. Lakkaraju, she mentioned that one of the victim's neighbors claims he witnessed the attack. She's going to try to convince you that that person is an eyewitness, but I want you to listen closely to what they actually saw. Because if you do, you'll learn that an eyewitness claims it was dark. It couldn't see Mr. Shepard, the person's face. Couldn't see the person's skin color, couldn't see their hair. He couldn't see anything. He actually misidentified Mr. Shepard. But the state, they didn't care. They saw what they expected to see. So finally, you might be thinking, is this case even a mob hit? That brings you to fact number 3. It's not. You're going to learn that the FBI, they actually have been trying to investigate this family for years. And Ms. Lakkaraju, she's going to be referencing that FBI agent's testimony. But by their own admission, you're going to learn that the circumstances of this killing, it was atypical for what a mob hit usually looks like. But not just that. We're going to hear from Mr. Shepard's daughter, Lauren Shepard. She's going to take this witness stand. And she's going to tell you her father is not a mob boss, and he certainly didn't kill Mr. Capello. She's going to tell you that they went to Los Angeles for a father-daughter trip. They were excited to tour colleges, spend time with each other. She's going to tell you that that trip was the last time she has spent time with her father in years. Why? Because that marshal and these prosecutors, they saw what they expected to see. Members of the jury, at the end of this trial, I'm going to come before you again. I'm going to ask you to review all the evidence. I'm going to ask you to come to the only verdict consistent with that evidence. Not guilty. Thank you.
Thank you. All right, the government, you may call your first witness and you may publish your evidence at
Yes,
this
Your
time.
Honor. At this time, the government calls Connor Wright.
One moment, I just got
Yes,
a
Your Honor.
message asking if we could close these blinds so that the recording comes out better. I would really like if someone could help me because I've never been good at these things.
I can try.
How many pages?
For the left. Got one.
Ms. Lakkaraju, you want to try this one as well?
Your Honor, if Connor Wright could actually step down, I think she's the one who has to figure it out.
Or someone could just like stand there. All right, I apologize for that.
May I proceed, Your Honor?
You may.
Could you please introduce yourself to the members of the jury?
I'm Deputy Marshal Connor Wright.
What do you do for a living, ma'am?
Like I said, I'm a Deputy Marshal with the U.S. Marshals. I specialize in WITSEC. That's witness protection.
Can you tell us exactly a little bit more about what you do with that specialization?
It's my job to relocate witnesses and make sure that they stay safe. I've been doing it for the last 14 years.
Do you have any specialized training for that kind of work?
Before becoming a U.S. Marshal, I was, trained the standard 19-week training camp. And then after that, I've been trained in everything from criminal investigation to protective services to handling evidence, extensive training to become a deputy marshal.
And during your time working as a deputy marshal, have you ever met someone named Barry Capello?
Yes, Mr. Capello was a witness under my protection until he died in 2021.
I want to talk a little bit more about Mr. Capello. When did you first meet him?
In 2018, he was testifying against a prominent crime family and then was moved into witness protection.
You mentioned that he was testifying against that crime family. Would you recognize a transcript of that trial if I showed it to you now?
I would.
Could you turn to Exhibit 7 in that binder in front of you? And just go ahead and let me know whether they're happy.
I got it.
Can you identify that document for us?
Yes, it looks to be a transcript of Barry Capello's testimony when he testified against the DeBruno crime family.
Does it look like it's been changed since you last saw it?
No.
Your Honor, at this time the government moves to enter Exhibit 7.
Any objection?
No objections, Your Honor. We actually stipulated that this was a public record under Rule 803A.
Sure, we'll go ahead and move it in.
And what does that transcript say?
In this transcript, Barry Capello names several members of the DeBruno crime family during his testimony and identifies the defendant, Augie Shepard, as the leader of that family.
And what happened after that trial?
After testifying against Augie Shepard and the DeBrunos, we moved him into witness protection.
And where exactly did you move Mr. Capello?
We moved him from Pennsylvania to LA.
Do you know how long Mr. Capello stayed in LA?
From 2018 to 2021, so 3 years before he was murdered.
And I want to shift gears and talk about that murder. Did you investigate Mr. Capello's kill?
Yes.
And ma'am, when exactly did that killing occur?
The evidence indicated that he was killed on June 26, 2021.
Can you tell us how Mr. Capello was killed?
There was an autopsy report in this case that indicated he died by strangulation.
Do you know the exact time of death?
The autopsy places it between midnight and 1 a.m. on June 26th.
And during your investigation, were you able to identify any suspects?
Yes. The defendant, Augie Shepard.
Why was the defendant a suspect in your investigation?
Well, there were three main reasons. First, a voicemail that Barry Capello left me before he died. Second, the car that Augie Shepard drove. And third, the description that an eyewitness left of the attacker.
Ma'am, I want to go ahead and walk through each of those three pieces of evidence one at a time. We'll start with that voicemail you mentioned. Would you recognize a transcript of that voicemail if I showed one to you?
I would, yes.
Could you flip to exhibit 14 in that binder? Just tell me when you're there.
I'm here.
Ma'am, what is that document?
It's a transcript of the voicemail that Barry Capello left me on June 25th.
Does it look any different than when you last saw it?
No.
Your Honor, the government moves to admit exhibit 14.
Any objection?
Objection to hearsay, Your Honor?
Response?
Yes, Your Honor, this is not hearsay. It falls under an exception. That's exception 8031. It's a present sense impression.
Do you have any response? Yes.
Yes, Your Honor, in order for this to be a present sense impression, we need to hear a lot more foundation. It has to be during or immediately after experiencing that event. Frankly, Your Honor, we don't know when this call was made, when it was made in relation to Mr. Capello allegedly seeing Mr. Shepard, and we need to hear that foundation on the record to know that if he was actually describing what he was seeing in real time, which is what's necessary under Rule 8031.
May I be heard?
You may.
Yes, Your Honor. First, may I proffer the transcript, lines from the transcript, exhibit 14?
Yes, I have it in front of me.
It says, call me when you get this. I think they found me. Augie Shepard just walked by my office window, and we made eye contact. Your Honor, the statement itself is self-authenticating under 8031. In this statement, the witness says, he just walked past my office window. That satisfies the necessity for immediacy under 8031.
Response on those grounds, Your Honor?
You may.
If I may proffer, the witness will actually testify that Mr. Capello called his wife well before he called this witness. This was a call made to the marshal. That's an entire phone call that was made before he even called the marshal, excuse me. Your Honor, that's a substantial amount of time. We don't know what was said on that call, if it could have affected what he was seeing, and that's exactly what the types of statements that 8031 is not supposed to cover. It has to be during or immediately after, and there was a substantial time gap between allegedly seeing Mr. Shepard and this voice call being made, and that's supported by this witness's own testimony in their affidavit.
May I be heard, Your Honor?
You may.
Yes, Your Honor. First, we'd just like to clarify something. The declarant of the statement in Exhibit 14 is the decedent Barry Capello. Your Honor, it doesn't matter when this witness, the agent, heard the statement. What matters is when the declarant, Mr. Capello, made the statement. And Your Honor, the declarant says he made the statement just after the defendant walked past his window. Your Honor, that's self-authenticating. He made the statement directly after he perceived the event that he described in the statement.
Sure. Can you respond to counsel's point, though, that between the interaction and this statement being made, that there was additional conversation between the declarant and his wife on a separate phone call?
Yes, Your Honor. I can just clarify the timeline momentarily.
Please.
Your Honor, first, this voicemail was made just after the decedent observed the defendant. Then, Your Honor, this witness who received the voicemail actually heard the voicemail at a separate time. However, the witness has the timestamp of the voicemail because it was left on her phone, and so we know, Your Honor, that there was a little bit of a time gap between when she heard it as opposed to when the decedent left it. That's the gap that Mr. Harper is referring to.
Okay, maybe I just want to clarify. Are you claiming that the declarant, meaning this is Mr. Capello's voicemail?
Yes, Your Honor.
That between him seeing the defendant and making this phone call, that the declarant made another phone call?
Yes, Your Honor. I
Okay.
agree with Ms. Lakkaraju. When this witness heard the voicemail, it's irrelevant. It's the fact that the declarant made a phone call after describing what they said in this voicemail, after talking to his wife.
Response?
Yes, please.
Yes, Your Honor. To that point specifically, that's an issue of weight, not admissibility. If Mr. Harper believes that the information that Mr. Capello described is incorrect, that he did not just see someone walk outside the window and that there was an entirely separate phone call, he can cross-examine the witness on that. But that's an issue of weight and not admissibility. And it doesn't mean that this document is not admissible or that it wasn't perceived directly after the event.
All right, I'm ready to roll. With respect, I disagree that it's a weight issue. I do believe in order to have an 8031 exception, we do need to have the statement be contemporaneous to the event. And given that there does not seem to be dispute over the fact that something happened between the event and this phone call, I'm going to sustain the objection unless you can lay the foundation that would put this safely in an 8031 exception category.
Yes, Your Honor. Ma'am, could you flip to Exhibit 4 in that binder? And just go ahead and let me know when you're there.
page number, please?
29.
Thank you.
And I just want to walk through when that voicemail might have actually been left, okay? To the best of your knowledge, when was that voicemail left?
12:50 p.m. on June 25th.
And ma'am, can you read aloud lines 8 and then 10 through 12 on page 29 from Exhibit 4? Your Honor, this is already in evidence.
Lines,
If you could read lines 8 through 9, just that first sentence, ma'am.
yes. Obtained warrant for Augie Shepard's iPhone 12, the phone, and all data associated with phone. No text messages on phone for any time period. Location places the phone at UCLA guest house. Is that the line you'd like me to read?
Ma'am, if you could just move a little bit upwards, read 10 through 12 aloud for the jury.
Checked call log from 0900 hours on June 25th to 0400 hours on June 26th. Phone received one call from wife Carmela Shepard beginning 0900 hours on June 25th, lasting 3 minutes. I believe that those are the lines you asked me to read.
And ma'am, could you just read that one line right after it, just the last sentence of that first paragraph?
A phone made one call to wife Carmela beginning at 17:45 on June 25th, lasting 4 minutes.
So ma'am, from what you can tell, that voicemail that we just talked about, was that left before or after the phone call to the wife?
From what I understand, I don't believe that there was necessarily a time period left by Mr. Capello, but I received that voicemail at 12:50. That's when he left it for me.
And ma'am, how exactly do you know that you received it at 12:50?
It was time-stamped.
Your Honor, at this time, we move to admit 14.
Response, Your Honor?
Please.
Respectfully, that foundation, Your Honor, that was about Mr. Shepard's phone, not Mr. Capello's phone. And this evidence doesn't actually prove that he did or did not make the phone call or the time in which he perceived Mr. Shepard allegedly and then made the phone call to this witness.
Response to that,
Yes,
Your Honor?
please.
Your Honor, we believe that the phone call that Mr. Harper was referencing was in fact that phone call. This shows location data from the phone that was analyzed in the cellular evidence paragraph in Exhibit 4. We know that this witness received that voicemail at 12:32 p.m. The witness testified, he just walked outside my window. Your Honor, that's sufficient foundation for the witness to testify that it was a present sense impression.
Counsel, to clarify, the information you just had the witness read was regarding Augie Shepard's phone, correct?
That is correct, Your Honor.
So that's the defendant's cell phone?
That is correct.
The voicemail that you wanted to admit into evidence, that's from the decedent's phone, correct?
Yes, Your Honor. Apologies. We just wanted to clarify, though, that this witness did lay the foundation that she received it at 12:50 p.m. And, Your Honor, we can lay further foundation exactly how we know the defendant was there through eyewitness testimony if we're given a little bit more leeway.
Sure. Let's do that.
Ma'am, during your investigation, were you able to find any evidence that would indicate where where the defendant, was at around 12:50 p.m.?
Yes, two things. I interviewed his daughter, and she confirmed that they were at lunch and then went to go get ice cream at two stores right adjacent to Kline Travel Agency, where Mr. Capello was when he left me that voicemail. I also found receipts that had timestamps on them that indicated the times they were at those locations.
So, ma'am, did you find evidence, just to clarify, that Augie Shepard was in fact outside Kline Travel Agency on or around 12:50 p.m. on June 25th?
Yes.
Your Honor, at this time, we move to enter Exhibit 14, the transcript.
Respectfully, Your Honor, this is still not sufficient foundation. The thing that's at issue here is when he saw him and when he made the call. Frankly, Your Honor, we don't disagree that he went to that restaurant and he went to that ice cream shop. That's irrelevant to the time between seeing Mr. Shepard and him making the phone call to this witness. We don't dispute that he was there. We dispute that he actually saw Mr. Capello at all. And we need to hear specific foundation as to the times as to when he saw him and when he made the call. And as of right now, all we know is that there was another intervening call in between, which certainly is sufficient time to not make this a present sense impression under Rule 8031.
Response to that, Your Honor?
Yes,
Your Honor, we'll just take this one by one. First, the witness testified, if I may proffer from Exhibit 14 again,
please.
that he just saw the defendant outside his place of work, and the witness testified that was around 12:50 p.m. Now, the witness has laid foundation that she has evidence the defendant was in fact outside the defendant's place of work at around 12:50 p.m., the same time. Your Honor, that makes it more likely than not that the declarant, Mr. Capello, did in fact perceive or believe that he witnessed the defendant outside his place of work at the time that he was identified there. We've laid the requisite foundation, Your Honor. We just have to show it's more likely than not that that's what the declarant perceived, and we've done that.
Brief response, Your Honor.
Sure.
The key word in Ms. Lakkaraju's argument is around 12:50. Was it 12:45? Was it 12:55? Was it 12:47? Was it 12:50? Like, we don't know at all whatsoever, and we need to hear specifically the time, because frankly, Your Honor, when it comes to a present sense impression, those minutes difference are very important, because it'll change whether or not he's experiencing that specific thing that he's testifying to at the exact same time as making the statement.
Response, Your Honor?
Sure.
Yes, Your Honor. The last question I asked the witness before admitting the evidence was whether or not she found evidence that the defendant was outside Kline Travel at 12:50 p.m., the time that she received the voicemail. She said yes. That is the requisite foundation to say that the witness perceived this event directly or just after he experienced it. But Your Honor, even if that's not the case, we still believe that this is not hearsay under Rule 807, the residual hearsay exception, if I may be heard on that.
Sure.
Yes, Your Honor, there's a number of prongs to Rule 807. First, we'd like to address the fact that 807B, both parties have already agreed prior to trial that all notice requirements have been met.
Sure.
So we're just dealing with 807.1 here. This statement has immense probative value in this case. We are charging the defendant in this case with witness retaliation. Your Honor, it is our contention today that this interaction is how the defendant identified the decedent in witness protection, and that after that incident, he was motivated to then murder Mr. Shepard. That's how he knew that he was in Los Angeles at the time. That has immense probative value, and it's incredibly important for the jury to hear, as it was the inciting incident for the crime.
Response, Your Honor?
Sure.
Frankly, there is no motive to be derived of Mr. Shepard from Mr. Capello claiming that he had seen him. And the important language in Rule 807 is that this specific voicemail has to be more probative on the point for which it is offered than any other evidence the proponent can obtain. Your Honor, we just went through multiple foundation about receipts, GPS location data, where he was. We know that he was there. Frankly, Your Honor, Ms. Lakkaraju has made her point, and there's no need to include hearsay onto the record under the residual exception at all, because we've already proven that he was there, and it doesn't actually go to the specific contention that Ms. Lakkaraju is making. At the end of the day, Your Honor, there was a phone call in between the decedent seeing Mr. Shepard and calling this witness, and that we don't know the times at all. It's not a present sense impression, and it doesn't fall under the residual exception either.
Response, Your Honor?
One moment. I would like you to respond. I'm going to put the 807 on the side for a moment because I don't think it's applicable to this type of evidence. But I would like you to respond. We have the receipts. They create a 5-minute window. As you're probably aware, the 8031 exception gives you a small time window. Is that 5-minute window sufficient for you for 8031?
No, Your Honor. The defense would argue that it's not. And more importantly, we know that he called someone in between. The whole point of 8031 is that people are being truthful as they're experiencing something. That they haven't been influenced by someone else, that they haven't seen anything else. And frankly, Your Honor, not only is there a 5-minute time gap, which is substantial, but we know that he called someone within that time gap. There's not
Can you proffer that
additional
evidence for
reliability.
me? Pardon,
Yes,
I
Your
didn't
Honor.
interrupt you.
No worries. Your Honor, it's in the witness's affidavit. I can read the lines.
Can I get a page number, actually?
Of course, it's page number 11. It's under the heading number 6, Death Investigation. It's the third paragraph down. I'm going to be starting at the second sentence.
Sure.
He reported seeing Augie Shepard during lunch and was afraid Shepard had seen him. She told him that, I'm going to start one line above. I interviewed Adriana Capello. She was hysterical. She said that on June 25th, 2021, Barry Capello called her frantic. He reported seeing Augie Shepard during lunch and was afraid Shepard had seen him. She told him that it was unlikely and it was actually Shepard because what would he be doing in LA? But recommended that Barry call me just in case. Your Honor, after that, that's when that witness made that phone call.
Response?
Please.
Your Honor, there is not a single timestamp listed in that entire paragraph. We have no idea when that phone call happened. For all we know, lunch is a pretty broad time frame. It could have happened hours after.
A response, Your Honor?
I'm ready to rule. I think that given that the receipts proffered by counsel place this phone call within a 5-minute window, the 8031 judicial notes says that 5 minutes is contemporaneous enough for the court, so it will be contemporaneous enough for me. Without a date stamp on the phone call to the wife, we're going to assume that we don't have the ability to prove that that happened and broke that causation chain. So I'm going to admit the statement at this time, and you may
Yes,
proceed.
Your Honor.
Yes, Your Honor.
Ma'am, would you recognize that actual voicemail you received if I played it for you now?
I would, yes.
Ms. DeLacy, could you play Exhibit 13?
Call me when you get this. I think they found me. Augie Shepard just walked by my office window. We made eye contact.
Is that the voicemail you received?
Yes.
Your Honor, at this time, we move to admit Exhibit 13.
Any objection?
Pursuant to your prior ruling, Your Honor, we have no objection.
It'll be moved.
So, ma'am, in that voicemail, Barry Capello says that he made eye contact with the defendant. Did you find any evidence that the defendant was, in fact, in LA at this time?
Yes, when I interviewed his daughter, she indicated that the two were in LA on a college visit.
Why was that significant to your investigation?
Because the dates, June 25th and June 26th, when Mr. Capello received that call and when he was murdered, fell within that time period that Augie Shepard was in LA.
And ma'am, I want to move to that second piece of evidence you mentioned, that car. What car were you referencing?
I was referencing a dark sports car. An eyewitness to the scene identified a dark sports car as the vehicle that the assailant left in.
Do you know what kind of car the defendant drives?
We found evidence that while in LA, the defendant was driving a dark green Ferrari.
Then ma'am, I want to move to that last piece of evidence you mentioned, the descriptions of the attacker. How did you learn about those descriptions?
That same eyewitness that I just mentioned saw the entire attack, saw someone approach Mr. Capello from behind, strangle him with something, and then leave in that same dark sports car that I just described. They identified the attacker as around 5'10", white, male, and around 180 pounds.
Ma'am, you said that identified the attacker as being 5'10", white, male, around 180 pounds. Did the defendant match any of those descriptions?
Yes, the defendant is around 5'10", white, male, and 180 pounds.
Are you aware of any other identifying characteristics of that attacker?
We found forensic evidence at the scene of footprints that were left a size 11 shoe.
Do you know what size shoes the defendant wears?
Size 11.
So ma'am, after recovering all of that evidence, what did you do?
We charged Augie Shepard with murder and witness retaliation in October.
Thank you, ma'am. Your Honor, we have no further questions at this time.
Cross-examination?
Yes, Your Honor. May I proceed?
You may.
Good afternoon, Marshal.
Good afternoon.
I want to jump straight into your investigation because, ma'am, you're not an expert in organized crime, are you?
No, I'm not.
You actually retained one of those experts, true?
We did, yes.
I want to talk about what that expert did and didn't say. Because, ma'am, it's true, that expert, she says mob killings. They're usually done with a knife or a gun, right?
She said that's usually the case.
She said it's actually unusual for mob killings to be done with jumper cables.
She did say that it was unusual, but that given the circumstances, that Augie Shepard had found the decedent while they were in witness protection, that the murder weapon could have been different because of that specific circumstance.
Ma'am, you couldn't have bought a knife or a gun in any store in LA?
I believe in the report, our expert identified certain characteristics, such as the time period, the fact that the decedent was in witness protection, that meant the murder might have had to have happened quickly, so the murderer might have used whatever was on hand.
That expert also said that mob hits, they're not usually done by the boss of the mob, right?
That's what the expert said, but we didn't find any evidence that any of the workers of Augie Shepard were in LA at that same time period, that he was the only member of the Bruno crime family who was there when the decedent was killed.
But that's a yes, that expert said it's unusual for the boss to commit the hit, right?
Yes, that usually would be unusual.
But it's your testimony that Mr. Shepard, he's a mob boss, right?
Yes, that's what we believe.
It's your testimony that he didn't order a hit, right?
No, we believe he didn't order a hit, but we also find no evidence that any other members of the Bruno crime family were in LA at that same time period.
You don't believe that he maybe called someone and bought him a ticket to LA to fly him out, right?
We didn't find any evidence of that, no.
No. You think that the mob boss went to this person's house by himself and killed him with his own two hands. That's your testimony, man?
Given the personal relationship between Barry Capello, the decedent, and Augie Shepard, yes, that's what we believe.
So I want to talk about whether or not the forensic evidence matches that story. Because, Marshal, you have a lot of experience in criminal investigation, true?
I do, yes.
And I'm sure you were thorough with your collection of evidence in this case, right?
We were.
You looked at Mr. Capello's car.
We did.
Looked at his home.
We did.
Looked at Mr. Shepard's car.
We did.
Looked at Mr. Shepard's home.
Well, Mr. Shepard lives in Pennsylvania, and the focus of our investigation was the crime scene in LA.
So you didn't actually check Mr. Shepard's home?
No, Mr. Shepard wasn't near or around his home at the time of the crime.
So that's a no. You didn't check Mr. Shepard's home.
No, again, this murder was committed in LA, where Mr. Shepard was at the time.
But I'm sure you also checked his hotel room, right?
We checked his hotel room, but we didn't find any evidence.
So I want to talk about what you didn't find in all of those places. Because in all of those places, you didn't find any DNA linking Mr. Shepard back to this crime.
No, we didn't.
All those places, you didn't find any fingerprints tying Mr. Shepard back to this crime.
No, but I want to be clear. The eyewitness identifies the attacker as someone wearing gloves, so we wouldn't expect to find fingerprints.
Well, ma'am, in any of your searches, you didn't find any gloves, did you?
No, we didn't find any gloves.
Didn't find any clothes that matched the description of the attacker.
No, again, Mr. Shepard left LA soon after the murder. We didn't find anything like that in his hotel room.
You didn't find any security footage from the hotel showing that he had left. Right?
No, there were no security cameras at the exits.
You didn't find any security footage from the neighborhood to see if he was there.
No, there were no security cameras, unfortunately, on the street where the decedent lived.
So, I want to talk about that eyewitness you mentioned earlier. You said that person, they saw the entire attack, right?
That's what they described, yes.
You said that they saw a green car.
I said that they saw a dark-colored sports car.
So let's be a little bit more specific, ma'am. That eyewitness, they actually said it was dark, right?
They did say it was dark outside. It was around midnight.
You asked them, well, what color was the car, right?
And they said they couldn't quite tell because it was dark outside, but they could tell that it was a dark-colored sports car.
Well, first he said, well, I think it's black, right?
Yes, he said that it could have been black under the lighting.
And not just that, ma'am. He said, well, I don't know what the make is, right?
He couldn't identify the particular make, but he said that it was a sports car, perhaps a Ferrari.
So he couldn't tell you the make of the car?
No, he couldn't.
Couldn't
Said he
tell
was.
you- excuse
My
me.
apologies. He said he wasn't a car guy.
Couldn't tell you the model of the car?
No.
Couldn't tell you any other details except for a dark-colored luxury car, right?
Yes, a dark-colored sports car, and that matches the description of the car the defendant was driving.
So let's actually turn to his identification of the perpetrator. Because, man, you said that he identified that the description matched Mr. Shepard?
He identified someone that was white, male, around 180 pounds, and around 5'10".
Well,
That
maybe-
matches the description of Augie Shepard.
You know, he actually wasn't sure of this person's skin color, right?
He said that he only got a glimpse of the back of the assailant's neck, and from what he could see, he seemed to be white, but he wasn't exactly certain.
He said, I can guess he's white, but I'm not sure, right?
Yes, like I said, he said he only saw the back of his neck, so he wasn't exactly certain.
Couldn't see his hair, right?
He said that he could tell that his hair was dark. He saw him from behind, but couldn't tell me a specific hair color.
He said, I'm not sure what it was, but I guess it was dark, right?
He said that, yes, it was dark outside. Again, this happened around
He
midnight.
said, I guess his hair was dark, right?
Yes, he said that he had dark hair.
And most importantly, man, he didn't even see this person's face, right?
No, because the attacker came up to Mr. Capello from behind, he only saw him from the back.
So that's a yes. That eyewitness didn't even see this person's face at all.
No, never saw the face.
And it's true in cases like these, you sometimes try to get eyewitnesses to identify the suspect, right?
If that's possible, yes.
And you know, that eyewitness, he did an identification, true?
He was shown a picture of Mr. Capello, as well as the defendant and a couple of other people that showed a front view, yes.
Right. Detectives showed him a photo of Mr. Capello, right?
Yes, that photo, it's important to know, was taken from the front, and he only ever saw the assailant from the back.
Showed him a photo of Mr. Shepard, right?
Yes, Mr. Shepard was in the photo.
They said, tell me who you recognize in this photo, true?
Yes, that's what they said, and he said that he didn't recognize anyone except for the decedent, Barry Capello.
Well, let's break that down. He certainly didn't say, oh, that's the person that I saw, right?
No, again, this photo was from the front view, and he only ever saw the assailant from the back.
He said, I recognize my neighbor, true?
Yes, that's what he said.
But I don't recognize anyone else in this photo. That's what he said.
No, he said he didn't recognize the defendant by a front view.
So he didn't recognize anyone else in that photo except for Mr. Capello, true?
Yes, that's true.
But then they said, why don't you take a second look? Isn't that true?
They asked specifically if the defendant, Augie Shepard, was the person they saw on the night.
Well, then they said, look at this person here, right?
They identified him by his lineup in the picture, and they asked if that was the person that the neighbor had saw.
They said, look at man number 3. Are you sure it's not him?
They asked him if he looked familiar. Yes.
And he said, oh, I guess that could be the person I saw, right?
Yes, he said he wasn't sure, but that could perhaps be the assailant.
Thank you, Marshall. Thank you, Your Honor. I have nothing further.
Any redirect?
Yes, Your Honor. Ma'am, I just want to be clear, why exactly did you put Mr. Capello in witness protection in the first place?
Because he had testified against the De Bruno crime family, the crime family of which the defendant, Augie Shepard, was the boss, and named Augie Shepard as the boss in court.
And Mr. Harper asked you a lot about those identifying characteristics of the assailant. Can you tell us what they were one more time?
The eyewitness described a white male, around 5'10" and 180 pounds. That matches the description of Augie Shepard to a T almost.
During your entire investigation, were you able to identify a single other individual who matched every single one of those characteristics?
We looked into alternative suspects, and we didn't find anyone else that matched the description like that.
Thank you, ma'am. Your Honor, we have no further questions at this time. And barring any recross, we ask that the witness be excused.
Yes, Your Honor. Recross.
Sure.
Marshall, I want to talk about the relocation of Mr. Capello that you just mentioned. You moved him to LA, right?
I did, yes.
And you specifically tried to make him impossible to trace, right?
We did, yes. We tried to keep our people in witness protection as safe as they can be.
So his address wasn't listed anywhere?
No, we tried to keep his address out of public information as well as any identifying information.
It wasn't listed under Mr. Capello?
No, he wasn't, of course not.
It wasn't even listed under his new name?
No, we tried to keep his address private.
And you certainly didn't find a note in Mr. Shepard's pocket of Mr. Capello's address, did you?
We didn't find any notes on Mr. Shepard when we booked him, nothing that indicated an address.
Thank you, Marshal. Thank you, Your Honor. Nothing further.
Anything else from the government?
No, Your Honor, we rest our case in chief.
Sure. You may be excused.
Thank you.
All right, how's the jury doing? You want to just keep going? Fabulous. Defense, you may call your witness.
Of course, Your Honor. At this time, the defense calls Miss Lauren Shepard to the stand. May I proceed?
You may.
Good afternoon, ma'am.
Good afternoon.
Can you introduce yourself to the members of the jury?
Hi, I'm Lauren Shepard.
What do you do for a living?
Well, nothing, I guess. I just graduated high school back in Philly, but I'm hoping to go to college, actually, in the fall, out here in LA.
Ma'am, I want to get right to how we got here. Do you know why you're testifying today?
I think so. My dad, Augie Shepard, is on trial today.
Do you know why?
Yeah. We were in LA last summer around June 25th when Barry Capello passed away.
I want to take a few steps back. Talk about your relationship with Mr. Capello.
Okay.
Do you know who that is?
Yeah, he was my dad's old friend. We called him Uncle Barry. He'd join us for holidays, New Year's. He even came to Thanksgiving once. I was really sad to hear about what happened to him.
Did you go to LA to see Uncle Barry?
No, we went to LA to visit colleges. I told my dad that I wanted to go to the West Coast for colleges. It was a whole thing. He organized a nice little trip for us.
Let's talk about your trip a little bit more. Where all did you go?
Well, we flew into Oakland, and then drove down the coast, visited Santa Barbara, Berkeley, and ended at UCLA.
So to be clear, ma'am, did you only go to Los Angeles?
No, like I said, we were driving around the coast, but yeah, we ended in LA.
So let's talk about your day in LA. When was that?
That would be June 25th.
And what all did you do that day?
Well, we visited the campus, walked around, talked about some college classes I might take there, and then we got lunch and ice cream later on.
What about in the nighttime? What'd you do there?
We went back to the hotel, and then my friend texted me about a party at UCLA, so I went to that too.
I want to walk through your day piece by piece. Earlier you mentioned that you went to lunch. Where'd you go?
Some Italian restaurant, I think it was called Pomodoro.
And you said you got ice cream. Where was that?
Just a few stores down, Saffron and Rose.
No, ma'am, I want to ask you a specific question. Do you know some place called the Kline Travel Agency?
Yeah, I do now. I guess it was on our walk between those two places. The police asked me about it when I talked to them.
Did you pass that travel agency?
Yeah, I did.
Well, I want to talk about what happened when you were passing that travel agency. On that walk over, Did you see your dad look at anyone?
No, just me while we were talking.
Did you see him get upset or angry?
No.
And did you see that storefront?
Not at the time, but I realized we did pass it once the police asked me about it.
Well, do you remember seeing any people in that storefront on that day?
No, I'm not even sure if I looked in the window or anything.
Did your father mention seeing any people in that window?
No, he didn't.
So let's move to the nighttime. What'd you do after lunch?
Like I said, we went back to the hotel for a few hours, went back to dinner, and then, well, I went to that party with my friend.
I want to be upfront with the members of the jury. Did you tell the police that you went to that party?
Not at first. Look, I was only 17 at the time. I knew my dad would freak out if he knew I was going, so I snuck out and I didn't tell the police because I didn't want my parents to find out.
Let's talk about what happened at that night. Before, what time did you leave?
Maybe around 11:30.
What was your dad doing then?
Sleeping. Long day. He was passed out.
Objection, Your Honor, speculation. May I be heard?
You may.
Your Honor, we don't have enough foundation on the record for this witness to make the opinion that her father was sleeping. We don't know what he looked like. His eyes were closed, was he snoring? That's a fact of contention in this case, so we need to hear more foundation on the record before she can form that opinion.
Response, Your Honor?
You may.
She was in the room with her father. Certainly she can testify that he was sleeping. We don't need to go into the nitty-gritty of whether or not his eyes were closed, how he was laying on the bed. This is his daughter. He can tell whether or not someone's sleeping. Frankly, I could probably realize if he was sleeping, Your Honor.
Response?
Please.
Your Honor, if she's able to form that opinion, she needs to say so on the record. We don't know where she was. We don't know how far away she was from her father. We don't know the angle she looked at her father at. Members of the jury, if it is a fact of contention in this case, we need to hear more foundation on the record as to how exactly she knows that fact, because we don't believe that her father was sleeping during that time.
To be clear, can I clarify, Your Honor?
Sure.
The question I asked was, what was your father doing when you left? She was in the hotel room. Certainly I'm not going to ask her to testify to what he was doing while she was not in his presence, because certainly she can't testify to that. But I'm asking what she specifically saw when she was leaving. And she could testify to that, and there's no additional foundation needed on the record.
Response?
Sure.
Your Honor, that's exactly what we're objecting to. Her opinion of what she saw when she was testified. She said that she saw him sleeping. We don't have enough foundation on the record for her to say that he was actually sleeping at that time. We need to hear what he looked like, why she believed that. Were his eyes closed? Was he snoring? Was he lying down? We don't have any of that on the record. Because if I may proffer, Your Honor,
Sure.
it is our good faith belief that this witness did not observe her father sleeping at that point, and that that's not actually what happened. So we need to hear more foundation for how she came to that opinion.
Counsel, did she observe her father sleeping?
Yes, Your Honor, she was in the room with him.
Okay,
Just a matter of her cross.
Sure. I'm gonna let her testify to what she observed, and you're welcome to cross-examine on whether he was actually conscious or not. Sure.
Yes, Your Honor.
Overruled.
I'll just ask the question one more time, ma'am. What was your father doing as you were leaving to go to that party?
He was sleeping in the bed.
What time did you get back?
Kind of late, 3 in the morning.
What was he doing when you got back?
Still sleeping.
Well, I want to be clear. Did he look like he had moved at all?
From the bed? No.
Did you see any things moved around the hotel room?
No.
Did you see any changed clothes?
No, it looked like just how I left him.
Did he look disheveled?
You know, he'd been rolling around in the bed, but no, not really.
Did he look sweaty or tired?
No, he didn't.
So, ma'am, I want the jury to be perfectly clear about what happened that weekend. How long would you say you were with your father that entire day?
I mean, the whole day. Up until that party, we toured the campuses together, got dinner, got lunch, and I was with him in the hotel room.
Ma'am, in all that time, did your father ever look angry?
No?
Did he ever look upset?
No, I mean, this was a college trip. That's why we were there.
Did he look like he was stressed or frustrated about something?
No, not at all.
Did he look like he was planning something?
No, I mean,
Objection, Your Honor. Speculation. How would this witness know what he would look like if he was planning something?
Response, Your Honor?
Rephrase your question.
Yes, Your Honor.
Sustained.
I'll be more specific, ma'am. Did you hear your father mention the name Barry Capella?
no, I never heard that. We were just there for that college trip.
Thank you, Ms. Shepard. Thank you, Your Honor. I have nothing further.
Cross-examination?
Yes, Your Honor. May I proceed?
You may.
Good afternoon, ma'am.
Good afternoon.
I'm just gonna ask you some questions today, and then we'll get you out of here, all right?
Okay, thank you.
Ma'am, you know that your dad is on trial for murder today.
Yeah, I do.
You love your dad, don't you?
Of course.
You care about him a lot.
Mhm.
You'd agree with me that today you are testifying on his behalf, right?
Right, I'm here to say everything I did with him that day.
You are here to say that all voluntarily, right?
Yeah,
Ma'am, you'd agree with me your daddy raised you for your entire life.
yeah, him and my mom in Philly.
You don't want him to spend the rest of his life in prison.
No,
Would you lie for him?
no, ma'am, I wouldn't lie for him.
You're telling us today you wouldn't lie for your dad?
No,
You'd agree with me you actually did lie for him, right?
no, I definitely didn't lie for him.
It's your testimony today you definitely did not lie for your father. Do I have that right?
That's right, ma'am.
Ma'am, let's talk about what you said to the police when they investigated your job, because you'd agree with me, they interviewed you, right?
Yeah,
During your dad's murder investigation.
they did.
You agree with me, they asked you questions about your father's whereabouts.
Sure.
They asked you questions about your father's whereabouts the night that Mr. Capello was murdered, right?
Right, they asked if he was in the hotel that night.
Not only that, ma'am, they asked you if you were with him that night, right?
That's right.
Now, a couple of months ago you said that you didn't tell the police at first exactly where you were, right?
Yeah, like I said, I didn't mention that party at first. I had snuck out successfully, and, well, I didn't want my parents to know.
Well, let's talk about what exactly you said at first. Ma'am, at first, you said that you were with your father the entire night, right?
That's right.
Then, the police, they pulled up some text messages, right?
Yeah, they pulled up the text from my friend with the invite, and then my Uber receipt, so I just told them what happened.
Well, hold on, ma'am. Well, we're going to take those one at a time. First, they just pulled up those text messages, right?
Yeah,
And then you changed your story.
well, that's when I told them about the party.
Well, ma'am, first, you said that you were gone for an hour because of that party, right?
Mm-hmm.
Ma'am, that's 1 hour you were not with your father that night.
Yeah,
That was a lie, wasn't it?
right. Like I said, then they showed me my Uber, and I knew I had to tell them I was really gone for longer than an hour.
Ma'am, you lied to the police during your father's murder investigation.
Right. I didn't want my parents to know what had happened. I thought they might freak out at me. I was 17 at the time, still a junior.
Let me just make sure I have this clear, ma'am. You were worried your father would freak out that you lied about a party when he was being investigated for murder?
Yeah, I guess I was.
And then you lied for him during that interview, right?
Well, no, ma'am, I wasn't lying for him.
Well, you lied about where you were that night, right?
Right.
Because then, like you said, the police showed you those Uber receipts, right?
Mm-hmm.
And then you changed your story again.
Right.
Now, you were gone from that hotel for 4 hours that night, right?
Yeah, that's right, from 11:30 to 3.
That is 4 hours you were not with your father.
Yeah,
4 hours you cannot account for his whereabouts, true?
sure, I wasn't with him then.
So, ma'am, you cannot tell us where he was during that 4 hour period, correct?
Well, I left him in the hotel, but I wasn't with him.
Ma'am, I want to talk about why that's important for this case. You know your dad knew someone named Barry Capello, right?
Mm-hmm, Uncle Barry.
He didn't like Barry Capello.
Well, he did for a few years, but not as of 2018.
That's right, ma'am. As of 2018, things changed, right?
Right. Uncle Barry said some things about my family, things that weren't true, and yeah, they stopped being friends.
Ma'am, you'd agree with me. Uncle Barry testified in court under oath against your family, right?
Objection, Your Honor, to speculation.
As to,
As to this witness's testimony about that trial, she wasn't there.
Response?
you may.
Your Honor, we believe that this witness has personal knowledge that that trial in fact did occur. She didn't need to be there. If she doesn't know, she can say she doesn't know.
Response, Your Honor?
You may.
We need to hear the foundation as to why Ms. Lakkaraju believes she would know that. Who told her about it?
Response?
Sure.
Your Honor, this is cross-examination. If the witness doesn't know, if she wasn't there for the trial, if she doesn't even know that it occurred, she can say that.
I agree. Overruled.
Yes, Your Honor.
You'd agree with me. Your Uncle Barry testified against your family under oath. Isn't that true?
He did.
Let's talk about what he said. He said that her cousin was a murderer.
Yeah, that's what he said.
He said your dad was a mob boss, right?
Yeah, I mean, I have no idea why he said that, but that's what he said in the trial.
You agree with me, that made your dad pretty upset, didn't it?
Objection, Your Honor. This question calls for speculation.
Response?
You may.
If she doesn't know the answer, she can say so.
Response, Your Honor?
Sure.
She's asking him about her father's opinions and feelings towards another person. If she has a quote or something that she remembers him saying, she can testify to that. She can't testify to his state of mind.
Yeah, sustained as phrased.
Yes, Your Honor. You'd agree with me that to you he appeared pretty angry after that testimony, right?
Yeah, I think he was hurt about what Barry was saying.
Ma'am, to you he appeared pretty upset.
Sure,
He appeared furious.
sure.
After that trial, he said, Uncle Barry is a rat.
That's right.
He said, I never want to hear that rat's name again.
Mm-hmm.
He said, Barry Capello is dead to our family.
That's what he said.
Nothing further, Your Honor.
Any redirect?
No redirect, Your Honor. Just ask to let me allow to step down.
Absolutely. Anything further from the defense?
No, Your Honor. The defense rests its case in chief.
All right, we can go ahead and proceed then to closings, presuming all of our jurors are doing well.
We just have one matter we'd like to address, Your Honor. Prior to
Sure.
closing arguments, may we publish Exhibits 7 and 14? They're in evidence.
You may.
May I proceed?
You may.
Your Honor, Mr. Harper, members of the jury. In October of 2018, Barry Capello testified in a trial, well, like this one. Took a seat in a chair like this, raised his right hand, and he did something that must have been very difficult for him. He swore to tell the truth. The truth about a dangerous man who was part of a dangerous organization. And members of the jury, sometimes when you take a stand against dangerous people, you have to pay a price. Today we heard that Mr. Capello certainly did. We heard that after he testified against the mafia, he lost his name, his identity, his family, his friends. And members of the jury, we heard that 3 years later, he tragically lost his life. Members of the jury, today we heard that after Mr. Capello took that deal, this defendant took his life. That's why we charged this defendant with murder and witness retaliation. That means that we had to prove two things to you today. First, that the defendant killed Barry Capello. And second, that he did so because of that trial that Mr. Capello testified in back in 2018. Members of the jury, we had to prove those two things to you beyond a reasonable doubt. We know that's a high burden. But it's a burden that we embraced, and it's one that we met. And we met that burden because today we told you about the deal that Mr. Capello took and how because of that deal, this defendant took his life. So let's walk through those things one at a time. First, that deal. Because today we heard that after Mr. Capello testified in that trial in 2018, this defendant was not happy. We heard that after Mr. Capello testified in that trial, he had to be shipped across the country, all the way to Los Angeles. He was given a new name, a new identity, a new job, a new life. And members of the jury, we heard exactly why. His own child told you on the stand today. Just think about all the things that the defendant said right after that trial, right after Barry Capello exposed him as the leader of a crime ring. Uncle Barry is a rat. I never want to hear that rat's name again. Barry Capello is dead to our family. Members of the jury, Mr. Capello had to be shipped across the country just to stay alive. But we heard that all of that came crashing down on June 26th of 2021. Because members of the jury today, we heard that on that day, Mr. Capello saw the defendant right outside his store on the streets of Los Angeles. We heard about the moment. Mr. Capello was so afraid that he picked up the phone, he called the police, and he said the words in Exhibit 13. Mr. Lacy, can we hear them again?
Call me when you get this. I think they found me. August Shepard just walked by my office window. We made eye contact.
Members of the jury, it turns out that Mr. Capello was right. He's so afraid. Because just hours after he said those words, he was murdered, strangled, outside his own home. And members of the jury, we know that this defendant is the person who was responsible for that. Now, I'm sure that Mr. Harper is going to come up here in just a moment and tell you that's not true. I'm sure that he's going to tell you exactly what he talked about on cross-examination today. Tell you that he didn't murder him with a gun. He didn't murder him with a knife. Members of the jury, just because this defendant did not murder his suspect with a gun or a knife doesn't mean that he didn't kill him. In fact, we know that he did. We know exactly how this defendant took his life. How do we know that? Because someone saw him doing it. I mean, just think about all the things we heard about that night. We heard that an eyewitness saw a white man, 5'10", 180 pounds, driving a sports car. We even know his shoe size. Members of the jury, that man had size 11 shoes. And then what do we hear about the defendant? We heard he's what? 5'10", 180 pounds. He drives a sports car. Members of the jury, we even know his shoe size. Size 11 shoes. Members of the jury, what does that leave us with? The same person who saw Mr. Capello hours before he was murdered is the same person who has no alibi for that murder, is the same exact person who was witnessed at the scene of the crime. Members of the jury, that is not a coincidence. On June 25th of 2021, this defendant saw Mr. Capello at 12 p.m. 12 hours later, Mr. Capello was dead. Members of the jury, today we heard that he made a deal. So the defendant took his life. Hold him accountable. Find this defendant guilty. Thank you.
Thank you. Closing from the defense.
Yes, Your Honor. May I proceed?
You may.
it please the court. Ms. Lakkaraju, members of the jury, people see what they expect to see. If there was one word you've heard a lot in today's trial, pretty basic one. No. Think back to the cross-examination of that marshal. Did you find any DNA? No. Did you find any fingerprints? No. Did you find any security footage? No. Could that eyewitness identify the attacker? No. Could he tell you his skin color? No. Could you tell you his height? No. At a certain point, you have to ask. Maybe that evidence isn't there because it doesn't exist. Maybe Ms. Lakkaraju is just seeing what she expects to see. And that's what we learned today, members of the jury. That from the very first moment that marshal stepped onto that property and saw that she was responsible for her own witness being killed, she had to find someone to blame. She assumed it was the mom. These prosecutors, they kept telling that story for over 2 years. And honestly, members of the jury, that's just not good enough. Because in criminal trials like these, the state can't just come in here and tell you a story. They have to prove it. They took on a burden of proof. I brought it up at the beginning of this trial. I'm telling you about it again because it's important, members of the jury. That burden, it stays here this entire trial, and it never moves to the defense team. It's the heaviest burden in our legal system, members of the jury. It's proof beyond all reasonable doubt. What does that mean? Pretty intuitive concept. Think about when you leave your house. You're not sure if you close the garage door. Did I leave the stove on? Did I lock the door? That moment of doubt when you feel when you go down the street, that's a reasonable doubt. And when you go back in that deliberation room, if you have any guesses, if you have any concerns, if you have any doubts, you cannot find Mr. Shepard guilty. Why? Because from the very first moment he walked through that courtroom and sat down at this table, he was presumed to be innocent. And that doesn't change until these prosecutors do their job. They didn't do that today, members of the jury. Because all you learned today is that people see what they expect to see. And the government, they saw exactly what they wanted to see with this case. But how do we know that? At the beginning of this trial, I asked you to pay attention to 3 simple facts. So let's walk through them again one by one. Let's talk about the evidence that we heard today. First, there's no forensic evidence tying Mr. Shepard back to this crime. Members of the jury, what would you even expect to see in a trial like this? They're telling you that someone murdered someone in cold blood, that he used gloves, that he was wearing gloves, that he was wearing a black sweater. I have to ask, where is that evidence? You didn't hear about any DNA, any fingerprints, any security cam footage. I even asked the marshal, ma'am, did you check his house in Philly? She said no. Maybe those gloves and that shirt would have been there, but frankly, members of the jury, you don't know, and that's reasonable doubt. Do you really expect that someone could sneak out of a car, could sneak out of their hotel, and the front desk person didn't see them? No housekeeper saw them? No other guests saw them? Did they even talk to everyone in that hotel? Members of the jury, I find that hard to believe that not a single person could see this man for 4 hours. No street cams? And no security footage from one of the homes? Members of the jury, it's getting to a point where, again, maybe that evidence just doesn't exist. So, let's go to that second simple fact. Because when that forensic evidence isn't there, you may think, well, maybe somebody saw this. Maybe somebody witnessed this crime. And it's Lakkaraju, she tried to convince you that someone did. She told you that a person identified Mr. Shepard, that they match the same characteristics. Is that what you heard? She said, I wrote this down on the cross-examination of Mr. Marshall, she said there was only one person that matched the description of being a white man, 5'11". Frankly, members of the jury, I can look around this courtroom right now and see 4 or 5 people that are consistent with a white man that's 5'11" and 180 pounds. And frankly, members of the jury, I find it hard to believe that they searched that entire city and couldn't find a single white man that was 5'11" and weighed about 180 pounds. Either they didn't look hard enough or that person doesn't exist. Just think about what that eyewitness actually saw. They admit themselves. It was dark. I couldn't see his face. I couldn't see his skin color. I couldn't see his hair. I didn't even know where he came from. That car. And she said that we identified the car. We know that it was the same car. How do we know that, members of the jury? Because that eyewitness certainly did it. They asked, is that the car you saw? He said, well, maybe. I think it was darkly colored. Well, was it green? No, it was black. Are you sure it wasn't black? Members of the jury, that's reasonable doubt. So, let's go to the last simple fact. This wasn't a mob hit. You heard from an expert in organized crime. Ms. Lakkaraju tells you, well, it doesn't matter whether or not he used a knife or a gun. Well, it certainly matters when they hire an expert who says that a mob hit, which is their theory of the case, doesn't happen like this. Yes, it's important. When someone that's been investigating crimes for years say, actually, it's pretty uncommon for these crimes to be committed with a knife or a gun. And certainly not jumper cables. And what explanation did they give you for that? Oh, well, he wasn't in Philly. Could he not go to a store and buy a knife? Could he not go to a store and buy a gun? No, members of the jury. And what is most incredulous about this story is that they want you to believe that the boss of a criminal organization, he didn't order a hit. He didn't fly somebody out. He didn't say, go kill this person for me, I know where they live. No, he's got his own 2 hands. He went to that person's apartment in the same car he was driving all weekend. And killed him himself? Risking getting caught? Does that make sense to you? Certainly didn't make sense to their own expert, who said that that was unlikely. See, at the end of the day, members of the jury, when things keep not making sense, you have to ask whether the version of the story these prosecutors are telling you is the right one. Whether or not the Mr. Shepard isn't in it is the right one. You heard from his daughter. Heard that that man raised her. That she lived with him. That he was not in the mob. That he certainly didn't kill Mr. Capello. That she was with him all week. She was excited to spend time with him. He was one of her favorite people in the world. That he was a good dad. But these prosecutors don't want you to hear that. Because they want you to see what they saw from the second they arrived to that crime scene. A dangerous mob boss committing a crime of revenge. But when we get into a courtroom, members of the jury, we can't see what we want to see. We have to see what the evidence tells us. Members of the jury, there is simply not enough evidence to prove their story. Why? Because people see what they expect to see. But when you go back in that deliberation room, members of the jury, I'm confident you're going to see what the evidence shows us. I'm confident you're going to find Mr. Shepard not guilty. Thank you.
Thank you. Do we have any rebuttal from the government?
We do, Your Honor. May I proceed?
You may.
Members of the jury, if there's one word that really sums up the defense's case today, it's the word no. Does their client have an alibi for the murder? No. Did their only witness today tell the truth to the police when her father was being investigated for the murder? No. I mean, members of the jury, the way that Mr. Harper tells it, his client is the unluckiest man in the entire world. I mean, he's so unlucky that a car that looks just like his is seen at the crime scene. He is so unlucky that someone that looks just like him, same height, same weight, same gender, same race, same shoe size, members of the jury, is seen committing the crime. He is so unlucky that we have someone on tape, the same person who was dead to his family, saying, I saw Augie Shepard. We made eye contact 12 hours before the murder. Members of the jury, no one is that unlucky. Mr. Capello made a deal. This defendant took his life. Don't let him get away with it. Find him guilty. Thank you.
Thank you. We'll now take a moment for our judges to fill out their ballots. And
Take mine before I run out. So I see